Our next seating involves Mark Spognardi, Michael Lolito, Gabrielle Semmel, G. Roger King, Elizabeth Bunn, and Manish Sharma. Greetings, everybody.
Good afternoon.
Mr. Spognardi.
Thank you, board members. My name is Mark Spognardi. I'm a partner at the law firm of Couch, Spognardi, and Bayaki in Chicago, Illinois. It's a great pleasure to be here with you today. I started my career in labor law almost 30 years ago, working as a staff counsel to two different board members, not at the same time. I'm presenting the views of myself as a management side attorney, my firm, my clients, and other concerned business people that I deal with on a day-to-day basis. And I want to focus my attention on the most important subject that I see, which people have addressed, and I'll try not to be redundant, but that is the necessity to have a pre-election hearing to determine the eligibility of somebody that may be a supervisor, a manager, or a confidential employee. These issues, I believe, are the linchpin and critical to resolve as early as possible in order to preserve laboratory conditions so that employees can cast a free and informed ballot, secret ballot. As you're well aware, the act was passed to encourage unionization and collective bargaining. It gave employees the right to organize. It gave them protections from employers taking reprisal, retaliation against them for exercising those Section 7 rights. In structuring the act, Congress, through the Taft-Hartley Act, the amendments, made it clear that supervisors are excluded from the protections of the act. As the Supreme Court said in Bell Aerospace, a division of Textron, Congress also understood, and the board at the time understood, that managers, confidential employees, are excluded from the protections of the act. They cannot be organized. Okay? This is simply a basic management versus labor analysis. It's, in essence, a class conflict analysis, but it is the way this board and the National Labor Relations Act has been set up and has worked well. As the Supreme Court also recognized in Bell Aerospace and recognized in Yeshiva University, management or employers are entitled to the absolute loyalty of their supervisors, of their managers, of their confidential employees. Supervisors and the others, they're expected to act in the interest of the employer. They are agents of the employer. Their actions bind the employer. Statute for supervisors, Section 211, says explicitly they are people that hire, they fire, they reward, they discipline. They can make the employee's day, they can break the employee down. At the end of the day, though, the employer is entitled to their loyalty, and they have to be excluded. This determination has to be made at the very beginning. In the effort to proceed with quicker elections, I believe the unintended consequences will be even further delays after the election. If a person is a supervisor and they are not excluded from the unit, they're going to be out soliciting cards or urging support for a union. It is coercive of employee rights. It taints the showing of interest. It subjects itself to administrative investigation and dismissal of the petition by the regional director without a hearing, administratively. But problems continue if you have a valid showing of interest and you're proceeding to an election and you don't resolve these linchpin issues immediately. If the disputed individual is actually a supervisor and aids and abets the organizing efforts, it can amount to unfair labor practice of unlawful domination and assistance. It destroys laboratory conditions. On the other hand, if it's a straw boss or a lead, if they're actually a supervisor, their comments, their actions, if they go beyond mere facts and opinions, they could be threats or promises or both. They could be unlawful. They have a binding effect on an employer, could be grounds for objections, unfair labor practice, and resulting setting aside the election. This all, in my view, can be avoided by having a hearing to decide eligibility where the parties could not reach agreement. Great effort is put in the regions to have the parties try to reach agreement. Even where the parties do not reach agreement, in my experience, in the regions I've worked in, which is primarily Regions 13, having a hearing does not delay the election according to the board's current time guidelines. As the board has acknowledged in its many opinions, determining these issues is a vexing problem. Section 9 of the Act requires a hearing. Evidence has to be taken. Often there are no bright lines, but the consequences of rushing to an election without determining these linchpin issues, I believe, could result in further delay than is experienced now.
You're out of time. Okay.
Thank you.
You use as an example a supervisor potentially tainting an election by card solicitation and having supervisory status at the time.
Yeah, prior to the filing of the petition.
Right. And of course, in that example, card solicitation by a 211 supervisor prior to the filing of the petition would have an effect on the filing of the petition if that circumstance becomes a ULT, is presented as an unfair labor practice.
No, it's administratively handled. My experience is you contact the region. You say, yeah, petition's been filed, and we've got evidence that it's tainted. We have evidence that the cards and the signatures were gathered by a supervisor. And then that evidence is looked at and investigated by the region, by the field staff, without a hearing, administratively looked at, and can result in the regional director dismissing the petition administratively, and then the petitioner is free to later file an untainted petition. But there's no hearing in that circumstance.
Mm-hmm. And is it your position that the NPRM would alter that part of the process?
No, my position is not that it would alter that part of the process.
Okay.
I would like to have a hearing on that issue, but that's not the way the board has worked, and as far as I know, as far back as I've practiced, it's never worked that way. It's handled administratively, and showings of interest under board rules or board policy, I believe both, are not, the showing of interest itself is not subject to hearing or litigation at the pre-election hearing. That showing of interest is a determination made administratively by the regional director.
Right.
The problem is later,
right,
during the campaign period, after the decision
right,
of direction.
I understand. But in terms of that particular example, that there are processes in place and as far as I understand, there's no suggestion that process would be tampered with.
Not by your proposed rule, no, not at all.
Okay.
Mr. Spognardi, I just have one question, and I'll ask it one time, but I'll ask all of the members of this seating to address it if they don't mind. And it's this: if we found a way to address supervisor status, managerial employee status, and confidential employee status before the election, but we adjusted the board's internal procedure so elections took place as quickly or more quickly than they occur now, would you support such an approach?
And I have an additional question for everybody on top of that question, which Phil stole from me. I was going to ask it. Good question.
If you found an approach that worked for both parties, as the statute is supposed to do, I would not oppose that. Okay. What I think, though, here is we have a situation where the rules that have existed have worked. People might complain about delays, but in my experience, there aren't significant delays. It's very, I know of no attorney who is successful in Chicago in choosing an issue to go to hearing to try to delay an election. They're all held within 42 days. It just doesn't happen where I come from. They don't let you get away with that, okay? And they know how to establish and shut down an issue on the record. Oh, he knows how to fire somebody? We don't need any more evidence. Move on, counsel. So in this instance, I believe the rule has functioned fine, and we're going to deal with the law of unintended consequences of having many more delays on the back end.
Thank you.
Okay, I revoke my group question, but there's a piggyback question just for you.
Oh, I'm sorry.
It's
I
okay. Okay, if these three exclusions are so important, confidential, managerial, supervisory, and we had a statement of position that was up front earlier than the hearing, depending on when the hearing is, would you be opposed to the employer having to take a position on what positions were covered by those exclusions?
Well, if it forces the employer to box itself in, I would.
Okay, assuming there's some opportunity to amend at some later point.
If there's procedure involved, I mean, that's something that can be examined.
Okay.
I don't see a delay in the process occurring that really resolves. I don't see any delays being caused by there being a lack of a written position statement up front outlining the issues. And in fact, my experience in the board is you are readily contacted by the board agent, and they ask you, what are the issues? What are the issues?
Right, I'm just talking
Send me
about
an
those three
email.
exclusions because that has come up in prior testimony today.
Okay.